I beg the indulgence of this court. I'm hyperventilating because I'm very, very upset. I will leave this court immediately because I'm sure I have hypertension. Samala v. Valencia, 512 Scra. 1. Decided in 2007. Here is what the Supreme Court said. Respondent cannot feign ignorance of the fact that the title he submitted was already canceled. In other words, the Supreme Court is saying, we are concerned, we are aghast that the lawyer knew that the document he submitted was false. Respondent failed to comply with Canon 10 of the Code of Professional Responsibility, which provides that a lawyer shall not do any falsehood, nor consent to the doing of any in court, nor shall he mislead or allow the court to be misled by any artifice. It matters not that the trial court was not misled by respondent's submission. Notice the court said, even if that false document did not mislead the court, still the lawyer is liable. Because the burden should not be placed on the court to determine whether the document is true or not. It is the duty of the lawyer who is introducing it. It matters not that the trial court was not misled by respondent's submission. What is decisive in this case is respondent's intent in trying to mislead the court by presenting this document. That's what the Supreme Court said. If the lawyer willfully introduced fake document, the Supreme Court will condemn the lawyer. I will see what the penalty was. Accordingly, the court finds the lawyer guilty of misconduct and violation of Canons 21, 10, and 1 of the Code of Professional Responsibility. He is suspended from the practice of law for 3 years, effective immediately upon receipt of this resolution. That is a decided case. It binds us all here. But that is in the case of a lawyer who knowingly and willfully introduced a fake document. Now let us grant the presumption of innocence to the prosecution panel. Suppose they did not know, as they indeed said in their pleading, they could not vouch for the authenticity of the document. Do they still have any liability? Yes, said no other than former Chief Justice Enrique Fernando, one of the most brilliant lawyers produced by this country. Justice Fernando wrote, in the case of Berenguer v. Carranza, 26 CRA, (26 CRA 673), promulgated in 1969. The lawyer had, in the preparation of the fake document, the lawyer had nothing to do with it. And therefore, the charge of deliberate deception obviously cannot be sustained. But, the court went on, would that of itself entirely exculpate him from any responsibility? The answer must be in the negative. Maski hindi mo sinadya, maski hindi mo naintindihan na peke pala yon, pag na-introduce mo yan evidence at natuklasan na peke pala, ay may pananugutan ka pa rin pala. As was correctly pointed out in the complaint, his failure to exercise greater care did result in the confusion and prolongation of the suit. Kasi nalilito kami eh. Under the circumstances, it would be to err on the side of undue leniency if he would be held blameless. He had incurred liability. His fidelity to his oath as attorney was less than entire. Every member of the bar must be on his guard, lest through oversight or inadvertence, the way he conducts his case or the evidence he presents could conceivably result in a failure of justice. Even if there be no intent to deceive, therefore, a lawyer whose conduct, as in this case, betrays inattention or carelessness, should not be allowed to free himself from a charge thereafter instituted against him by the mere plea that his conduct was not willful and that he has not consented to the doing of the falsity. The Supreme Court found him guilty and issued a penalty of reprimand with a warning that repetition of the offense will be more severely left with. This is the ruling of the Supreme Court. Pinalitan na ba natin itong mga ruling na ito? Pwede na pala ngayon, maski media account, pwede mo nang i-narrate sa korte na hindi mo naintindihan kung tama yun o totoo yun o binigay yan ng PR, ng Dirty Tricks Department na kung sinong PR firm. Come on! Wake up! We all know how politics is done in this country. Just because you admit that this is a quasi-political proceeding does not mean that you can turn this into a completely political circus. Kaya, I submit to my colleagues, I respectfully submit to these colleagues, my colleagues, what is the role of media while this trial is pending, while this trial is sub judice? Pababayaan na lang na ba sila na magbibigay ng kung anong lead dyan na identify tayo isa-isa. Itong mga senador na ito, pro-Aquino ito. Ito naman, pro-Corona. What does it say of our integrity? Pabayaan lang ba sila? Libreng-libre ba sila? In the name of freedom of the press? I think we should think very carefully about the sub judice ruling. While a case is pending in court, there is a gag rule. No person may orally or through other means, by media, for example, comment on the merits of the case. Even we are not allowed to do that. Shall we allow media to do that? Nilista tayo isa-isa, dito kaliwa, dito sa kanan. May kaso dito Ay di kung ganun pala, if this is going to be trial by publicity, let us invoke the Constitution and ask for a change of venue. Perhaps out of the country. We all know that the Constitution itself recognizes that public opinion can be so prejudicial in a pending trial that under the Constitution, the Supreme Court may order a change of venue. Ganon katindi ang ayaw ng korte ng is public opinion that will teach lawyers who have trained for 9 years to become lawyers on what the law is or how it should be applied by people who have never applied the law in trial court. Kung ganito ito, huwag na tayo magbasa pa. That is all, Your Honor. Thank you.
Thank you.